on this morning's Ag Issues program. A pleasure, as always, to bring back to the program Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us on the program this morning. Roger, good morning. How are you?
Good morning, Greg. Just fine, thank you.
Well, kind of curious, how much snow did you get up on the farm?
Looks like a little bit over 6 inches. I'd say somewhere between 6 and 7 inches of nice wet snow. It's just very much needed. My pond is just devastated and so low, and this is plus the 1.4 inches of rain a little bit over a week ago. You add that to this, I suppose there's probably about an inch of moisture content in this. That's very helpful. Very helpful.
Yeah, very much indeed. All right, let's get to it. And like we said, a lot of issues to go to. And the first one is a very familiar one to many, and that is the right to repair issue. And specifically, if you look at it, Colorado, our neighbors to the west, their right to repair law goes into effect at the start of 2024. But this is one that is, well, to say the least, it's not going away.
No, we've had at least 11 states that have introduced legislation on the issue in the last, I'd say, 2 or 3 legislative sessions. And Colorado's the only state where it's passed, but it's going to be up on the legislative schedule in a number of states again in 2024. And it's a big issue for farmers. When you buy new machinery, the manufacturer might view that as a transaction that is basically a technology lease and not a machine sale, or at least more as a technology lease than just a machine sale. And so the question really here is who owns the software and all that technology in the farm machine. And we get into all types of legal issues associated with that in terms of ownership of the technology and license to use it, whether you have to pay an additional amount to use that. And then, of course, the repair issue. And it's all caused because of this dramatic increase in computerization of equipment. That means that all types of data from that equipment is being sent to the cloud by a transmitter. And so the manufacturer is going to claim that only an authorized dealer can make repairs. So you've got a lot of economics that are tied into this. You've got a lot of legal issues that are tied into it. But that's basically the crux of the right to repair argument. And, of course, listeners are aware of the certain companies such as John Deere that have entered into memorandums of understanding on this issue, and other companies have gotten into those agreements in recent months. So, this in some of those agreements will say if the signatory to it tries to introduce or sponsors or lobbies for right to repair legislation, then the deal is off. So we'll have to see what continues to happen, whether this legislation will pass in other states. But you're right, Greg, this issue is not going to go away.
We know of John Deere has really been crosshairs of this. Are there other companies like John Deere that are not that far behind, or that they're just keeping a very close eye on it right now?
No, there are other companies that have entered into these deals. Pretty much similar to the memorandum of understanding, I should say, that John Deere entered into. So some of your major manufacturers out there are doing the same thing. But it's a big issue. It's a lot of farmers will obviously use new equipment that has all the computerized things on it. But it reminds me of this case you and I talked about it several months ago. There was a case in Southwest Iowa about this time last year. And the IRS went after this guy because they thought he was an antique collector and not a farmer, and therefore he couldn't deduct any of his losses on his farm return. This guy farmed with old tractors. And the newest one that he had 42 tractors, and the newest one that he had was 35 years old. And Judge Paris wrote that opinion in the tax court case, and she instructed the IRS, look, you don't have to farm with new stuff. This is the way the guy wanted to farm, and he was successful at it, had been since the 1970s, and he had various tracts of land, and he put his different tractors and equipment on those pieces, and he used them for those specific purposes, and that's the way he farmed. And she said in there the reason he did it was that he could repair it. He didn't have to pay anybody. He didn't have to worry about computerized stuff and all of this right to repair. He could do it himself. And he was certainly a farmer. And it's a funny opinion for people to read if they ever want to read it, where she takes about 40 pages to explain farming and agriculture to the IRS. But that's one where you had an individual that didn't want to deal with any of this new stuff. Just farmed with old tractors, and he was successful at it.
Roger, let's move on. And you look at the latest USDA numbers, and it shows about 40% of all farmland is leased. But to your point, as far as the topic is concerned, there's a requirement of good husbandry that needs to take place in a part of all ag leases.
Yeah, that's there, whether the lease is in writing or whether it's not in writing, whether it's just an oral lease agreement. So you might have a provision in the lease that says that the tenant is to farm with good farming practices in accordance with standard farm management, farm practices. That's known as a good husbandry provision, and it may get specific. You will grow these types of crops, you will do this type of fertilization, you will not do this, and so forth and so on. Other times there's even nothing in a written lease that's specified, but then the law will imply that a tenant is to use good farming practices, not harm the land, not cause soil erosion, those types of things. And there may be actually other statutes that would govern soil erosion or improper drainage, those types of issues. But if you remove topsoil, or you demolish buildings or fences, or you cut timber down, or you destroy cover crops, or you use improper tillage practices, or don't control weeds or insects, that can all be deemed to be a violation of a good husbandry provision in a lease or the implied good husbandry notion that's out there. So there's no specific legal definition, and that means the interpretation of what good husbandry means is left up to the courts unless that lease has a very specific clause that defines the term. You can always do that, but many people, of course, don't do that. And we had numerous cases on these. I remember one out of Arkansas in 2020 involved a good husbandry provision. The court said it was breached because of what the tenant was doing. We've seen them where the tenant started harvesting wheat too late, and that was deemed to be a breach of a good husbandry provision, and it caused a significantly diminished yield in the crop. A breach was also found in another case where the tenant removed manure at the end of the lease. Just took the manure with it so he could apply it on his own farm. But if it's just weather that's preventing the tenant from completing the harvest, and other farms in the area have been similarly affected, then that's something that is not the tenant's fault. And so that's not going to be a breach of a good husbandry provision. But I would say for people listening, if you're concerned about your tenant's farming practices, then you want to consider putting a clause in writing in that lease that details the farming practices that you deem appropriate and those that you don't.
All right, before we go to break, Roger, another thing that, I don't know how many years we've talked about this, but yet, again, some updates on the regulatory definitions of the waters of the U.S. bill, or WOTUS in this case, that we've heard about for so long.
Yeah, the most recent iteration of this, of course, is as a result of the Sackett opinion in the Supreme Court back in late May, and where the court really said that, gave us the definition of what a navigable water of the United States is, and it has to be relatively permanent. There has to be a continuous surface connection, and so then it became up to the regulatory agencies, the Environmental Protection Agency and the Army Corps of Engineers, to rewrite their rule to follow that. And of course, they had been there basically with the Trump rule, and then the current administration came in and changed that, kind of went back to the Obama rule, and the Supreme Court, in essence, said, no, the Trump rule was right. And so the agencies have to change that to that relatively permanent, continuous surface connection standard. Well, they purportedly did. They didn't go through notice and comment procedure. They cited a specific exception where they didn't have to make this public and have a hearing and open it up for notice and comments. And they just did it, and that's one aspect of what has upset a lot of farm groups on this. And then there's been a frontal challenge by 26 states, 24 states in one case, 2 states in another case, and the big case has been filed in the or there's a decision out of the Northern District in the Federal District Court in North Dakota, and we have a separate case involving Texas and Idaho with their claims. That continues to be challenged. And Texas and Idaho claim that the modified rule, this most recent one, oversteps state sovereignty and asserts federal authority over non-navigable waters. And that's you've got industry groups and ag groups that have joined in these lawsuits. So, but the standard is at the Supreme Court, and they were unanimous. And this is an important point. Some people will focus on, well, they had a fractured opinion, but they were unanimous on a couple of points. And the point that they were unanimous on was that the Sacketts did not have a wetland; they didn't violate the rules, and that that the current rule was wrong. Now, there's some difference in interpretation as to what the new rule should be, but on those main points, they were unanimous, which is unusual in a highly contested environmental case like this.
Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, is our guest this morning. We talked about farmland leases taking place, but you've got an update on considerations if you're interested in buying farmland.
Well, that's probably the biggest decision that a person is going to have to deal with respect to their farming operation as well as their legacy, is when to buy farmland, whether to buy farmland, what to pay for that farmland. But, Greg, there are lots of things to consider before signing on that dotted line, other than price. Of course, price is going to be the primary consideration, but there are other factors that do need to be taken into account that will affect the land's value to you that aren't necessarily reflected in a sale price. So I think if you kind of sit down and think through and list some of these, here's what I come up with. Make sure you account for any improvements that you're going to have to make. If we're buying land, if we think of it on what's it cost on a per acre basis, well, we need to think about what is it really going to cost me out of pocket if I have to make improvements to buildings and fences, drainage tile, and those types of things. Am I going to have a lot of dirt work that's done? Those types of things. So that should also be taken into consideration. Also check the watershed, potential drainage irrigation issues that you might have. Is the land in a drainage district? Now, for many in Kansas, that's not going to be an issue. In northeast Kansas, it might be. And what are the restrictions in the drainage district? Also, is there a potential for an endangered species habitat designation? Not so much in Kansas, although we get into issues with this silly lesser prairie chicken issue that keeps coming back over and over, which is again in the courts, which has been moved. The jurisdiction on that has been moved outside of Kansas now, but that is going on. But you get into states such as Texas and Florida and California, that is a huge issue that will affect land value. Is there an old dump site on the property? Now, this one, people may not think of this one, but those dump sites were pretty common up through the 1970s, and they may still exist in some corners of properties that are kind of remote. So you want to know about that. Are there any government contracts? Is there a CRP contract on the land? Are there any easements on the property? What's going to affect your ability to make money from producing crops or livestock on that land? And so you want to know what restrictions are on that land. Is it leased to a tenant? Now, this is a big one that gets messed up all the time. If there's an existing tenant and you buy land, you want to make sure that you know whether you're going to have to deal with that tenant or not. Has that tenancy been terminated? Just simply you buying the land does not terminate the existing tenant's rights unless they have a lease agreement that says that their lease is over if the current owner, the landlord, sells the land. Now, that's unlikely. I find that typically very common that auctioneers, real estate brokers, those types of people get it wrong on that particular issue. The lease is not terminated when a new buyer buys the land. The buyer takes subject to the existing tenant's rights, whatever those rights may be. So that's a big one. And then in Kansas, is there a subsurface tenant? So don't just think about the surface tenant farming the crops or handling livestock, a livestock tenant. Is there an oil and gas lease? Is there a subsurface tenant that is also involved? And so we need to to know about those things, and we can by checking public records, asking questions of the current owner, asking questions of neighbors, and make sure you physically inspect the property and get that seller to sign a thorough disclosure document. I think those are all considerations that we need to think about when we want to buy farmland.
Maybe the simplest but most important piece of advice on that: emotions. Don't let that drive your decision.
Yeah, that's a tough one. You may have this adjacent piece of land that has not been on the market for 40 or 50 years, and now you've got a chance to add it in, and it's going to be your legacy for your children, your grandchildren, your great-grandchildren, and emotions can take over, and then we see land prices that will skyrocket. I saw one of these. I was actually sitting in the Union Station in Chicago waiting on a train a number of years ago, and a train to come to Kansas. And, of course, in that area, you've got a bunch of Amish that are traveling from Indiana and Pennsylvania to family out in Kansas. And I was sitting there reading the Chicago newspaper that morning while I was just waiting for the train, and there was an article in there about a piece of Iowa land. Now, this was, 12 years ago, that sold for $22,000 per acre in northwest Iowa. No urban influence on that price at all. And I looked at that, and I leaned over to the Amish gentleman next to me and had him read that. And he shook his head, and he showed that to his wife, and he could not understand that. And then he turned to me and he said, "Somebody let their heart get ahead of their mind." And that's exactly what happened. It was a tract that hadn't been up for sale for about 50 years, and this guy wanted it, the neighbor wanted it, and they just started bidding against each other, and that price went up and up and up and up. Of course, you can't cash flow that at that level on your own, and so it just has to be an additional piece that they're adding to a larger farm, which is what it was. But you're right, Greg. It's tough, but if emotions get in the way, then price can skyrocket.
Another thing, as we wrap up the program, looking at the value of meals and lodging, but if they're furnished on the business premises for the employer's convenience. Well, in this case, looking at it tax-wise, income-wise, as well on the exclusion of meals and lodging from income.
Yeah, this is a C corporation benefit. So if you farm in a C corporation, you have the ability to provide tax-free meals and lodging to your employees, not your tenants, to your employees, and also get a deduction for that cost at the corporate level. Now, you have to be in a C corporation, and again, it's just for employees, not for tenants, but the meals and lodging have to be furnished on the business premises, and it has to be furnished for the employer's convenience and as a condition of employment. And if you do all of that, then it's not taxable to the employee, and it's deductible by the employer if those meal and lodging are provided in kind. Now, this is I could take the next 45 minutes and talk about this issue, and I will tomorrow in Salina for tax professionals. But that's an issue that, if we structure it correctly, can provide a significant benefit to employees that you cannot get outside the C corporation structure. Now, there are other reasons to not be a C corporation, so it's a very complex issue. Obviously, we don't have time to fully discuss it this morning, but that people need to talk to their tax advisors to see if that might work for them. If they have a relatively larger operation and they have employees, then this would be something that they might want to think about in terms of structuring it properly.
I think you hit an operative phrase there, though, if you structure it correctly.
Right. Yep, that's the key.
Yep, absolutely. All right. So, Roger, as we had several other topics we could discuss, but if people want to see what you talked about today on the discussion, they can go to your blog?
They can if they give me about 15 minutes, because I'm tidying it up right now, and then I'm going to post it on my blog, and then I'll send it over to K-State, and they'll post it on the Ag Manager website there, too.
All right. Sounds good. Roger, as always, very much appreciate it. Thanks.
Thank you, Greg.
That is Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us this morning on the Ag Issues program here on 580 WIBW.